Mr. Sanchez,
Yes, ma'am.
are you appearing pro se?
Yes, ma'am.
You've been observing what happens. You have 10 minutes to make your argument. You can reserve some of that 10 minutes for rebuttal. Would you like to reserve some time?
Yes, ma'am, if possible.
How much? You have to stand in front of the podium for us to even hear you.
Yes, ma'am, 3 minutes if possible.
3? Okay.
Your Honors, may I please the court? I am Raul Sanchez, Jr., pro se, and I'm here today on an appeal filed to determine if the lower tribunal erred in failing to consider the former wife's assets in the final distribution of assets. This appeal is not filed for emotional reasons on the part of the appellant, as alleged in the appellee's reply brief. This is the appeal that is filed for review to determine if the lower tribunal erred in not considering and comparing the former wife's income and assets, which stemmed from her part-time job and numerous lucrative active businesses, and submitted as proof of income and assets by the former wife after being compelled to do so by the court. The issue of appeal stems from the case of dissolution of marriage involving this appellant, who now appears as pro se, and his former wife, who has retained counsel from the inception of the divorce. This appellant prays that this court will consider his appeal and oral argument, reverse the final judgment in this case, and remand that the lower tribunal to fully consider and compare both parties' assets and income fairly as provided by Florida law. On or about November 16th of 2011, this appellant filed a motion for dissolution of marriage. On November 30th, 2014, after numerous delays stemming from several motions to compel the former wife's income and assets, a final dissolution of marriage was entered. And then on February 4th, 2015, the lower tribunal entered an amended omnibus.
Mr. Sanchez, why don't you, because you have very limited time, why don't you tell us what you think the trial judge did wrong?
Well, I have never seen any tax returns from Ms. Gonzalez from 2011 to 2014. The ones that she presented were all old ones. The bank statements that she provided were incomplete, not complete time as required by the law, and some didn't even go consecutively monthly. The ones that she did show, as the judge stated in the final dissolution of marriage, stemmed from anywhere between $7,000 to $9,000 a month in income into her accounts. She was never required or asked why none of her tax returns were ever filed. Like I said, to this date, I've never seen tax returns from 2011 to 2014. Aside from that, in my brief, it also states that she was underemployed or not properly, justifying the income as to her experience. Ms. Gonzalez has about 27 years experience as a paralegal. Most of the motions and petitions that were filed in those 3 years of this divorce proceedings were done by Ms. Gonzalez. I can't say for certainty, but I would not doubt by any means that she has been the one doing most of the work throughout this entire divorce proceedings, and I was found in a judgment to pay Ms. Gonzalez $18,300 some in attorney's fees, payable monthly at $500 a month until paid in full. Aside from that, they took out of my retirement account with the amount that she was entitled to, that I'm not arguing, the $21,000 and change that she was awarded by the court, an additional $5,000 that was agreed outside the chambers of the general magistrate between the counsel that I had at the time and the counsel for my former wife, that I would agree to $5,000 out of my retirement account if we reached a settlement and the divorce proceeding didn't go any further to incur any additional cost to either party. And I have all of the emails going back and forth from my then attorney and my former wife's attorney that they were just delaying the discovery evidence, that they wouldn't provide any of the income and asset stuff that they needed to be able to reach a settlement. When it got to the point that they had overpassed the amount that I had retained them for, well into almost $9,000 in excess, I immediately had to basically tell them to please stop because I had no way of paying that. I pay my former attorney $50 a pay period for that $9,000 sum that I went over from what I retained them. Aside from that, that was taken out of my retirement account against that this appeal was filed. So, they've taken already money out. They've taken other monies out in the sums of $1,700 and $1,800 from my retirement account, which I have no idea what they were for. Aside from that, the lower tribunal has held hearings, the last hearing, without me even being present or knowing about it. In our previous hearings, when my former wife was not present, the judge on the bench got a phone and reached out to her to question why she was not present in his courtroom. Yet I was never called the day that they had a hearing to withdraw that money on a quadro out of my retirement account. And basically, I will reserve the time for my rebuttal, what's left.
Thank you, Mr. Sanchez.
I guess it's now good afternoon. May it please the court, Brett Feinstein on behalf of the Appellee, cross-appellant, and a former wife. The knock on family law cases is that it's almost like the Wild West. There's no law, people complain that there's no evidence code and the like, but that's not necessarily true. And even though the court is afforded a lot of discretion because it is a court of equity, there are still aspects of law that it must follow. It's still a court of law, many principles. If I can direct my attention to the cross appeal first, the four issues that I brought up on appeal basically fit into that. And as a family law practitioner, we want the idea, it's a Latin idea, it's called semper idem, always the same. And we want the court to rule always the same on those certain issues, and these four issues fit into that. First, the uncovered, unpaid medical expenses. There's a statute, 6130 sub 8, which says it has to be divided on your pro rata or percentage basis share. In this particular case, the court entered a final judgment, and you see the exhibit to the final judgment is the calculation of the parties' incomes and their percentage shares. And that is the law of the case. My opponent has argued that he's appealing the final judgment, but he's not appealing the final judgment. His notice of appeal is only to the omnibus order, the amended final judgment. He never appealed the final judgment, and therefore, the law of the case are the parties' incomes and their pro rata shares. In this particular case, the judge split it equally.
Omnibus suggests that it encompasses everything.
Well, it was the motion for rehearing and the motion for attorney's fees. That was all that was noticed and that was argued at that hearing on January 26th. The order that came out on February 8th, per the court's ruling, and you have the transcript, was to amend the final judgment only as to those one or two issues, in this case the quadro, and whatever he was granted on rehearing, and also awarded the attorney's fees. So the final judgment was never appealed. Be that as it may, the law of the case in the appeal, he wasn't appealing the parties' incomes as to what was determined at that time. And with respect to the uncovered medical expenses, the court split it equally. Well, there are two reasons why that was incorrect. First, there's an agreement, the partial mediation agreement, which set forth the parties' percentage shares. At that time, it was 62%, 38%. So all the medical expenses that were not agreed to at that time that had to be paid needed to be split in that fashion. Second, going forward, because the court accepted the incomes and determined that, the pro rata share was 74%, 26% in favor of the former husband. That has to be what's going on from here on out. And last but not least, the court, and I don't know why, because when you see the testimony, or I'm sorry, the court's ruling, the rehearing, the answer was nope. I didn't know that was actually a legal word until before this appeal, but he said nope. He never set forth a manner of repayment of that $2,000, $3,000. We're claiming it's $3,000. He never set forth a matter of repayment. So that's one issue we're appealing. The second is the tax exemption. Again, under the idea of semper idem, always the same, the case law, Ford v. Ford, it is clear that if you're going to grant the party, the non-custodial parent, as it were, if you're going to grant them a tax exemption, they have to be current in their child support. And the court has determined there are arrearages here, and therefore believe the court should have properly awarded the tax exemption to my client alone until that point in time that the arrearages are brought current. In this case, initially at the rehearing motion, the judge wouldn't entertain it. He said, I'm going to leave it alone. He obviously changed his mind when he entered the order, because that's the only part that's handwritten other than the number of hours and the award of fees. And we don't have the reasoning for that. The third issue, equitable distribution of the one asset that we are contesting. There was evidence. And what the court said in the final judgment was, clearly, there was no evidence presented as to the value of the annual leave, and the only testimony was the former husband's testimony that said it's use it or leave it, except attached as Exhibit E to, actually, it was Exhibit E, it is to the appendix, there is an annual leave component. And we're saying what we brought up on rehearing is it states very clearly in the record, evidence that was admitted, that it has a value component. And I don't know why the judge determined that it wasn't the case, but he went along by saying clearly, hey, there's no evidence to this end, and there was evidence to that end. Finally, I guess the big ticket issue is the recalculation of child support. Now, in the partial mediation agreement, the parties came up with a temporary arrearage amount up through February of 2013, and it was premised on a guideline that was attached wherein the former husband at that time was provided with 100 and I think it was half the time, 165 days of the time sharing. Unfortunately, as the evidence that was presented occurred, former husband never exercised that time, both before and then after that agreement. And he was given a prospective award and a credit for child support for time sharing that he did not exercise. And the one thing it is discussed in the final judgment is the fact that he relocated to Fort Myers and he didn't exercise that time. The case law is clear, Bueller v. Bueller, as well as the statute 61.3 sub 11, that if you don't use this time, if you're given a credit for your time sharing, it's called the gross up method. If you don't get that time, you don't get a credit for it. And the evidence that was presented without objection, and again, contrary to the Wild West, we took the time to present all of the evidence of every day, every time, you don't get that. And that is a very large sum of money that, whether we agree with the child support guidelines and how the legislature did it at the time, that is money that came out of my client's pocket. And she properly and fairly testified as to why she was entitled to a redetermination, a recalculation of the child support. And we know, as I set forth in my brief, the temporary orders are always subject to review. In this particular case, we really presented the evidence to that end. So I don't know why the trial court didn't give us more guidance other than note why he didn't sit down and say, hey, I forgot this issue or I didn't address this. I just want it to be always the same for my client. Close out the case with the issues that we presented. And I believe that the record will show. I guess you can tell the trial court judge, you can remand it and say, we find X, Y, Z, please correct this, or conduct a hearing to consider the evidence that was presented. Finally, as it relates to the appeal, the issue of the $5,000 quadro, much ado about nothing, I believe. It was a ministerial action. The trial court forgot to put that in to the final determination of the quadro. The order of ratifying the report of the general magistrate said, it's for temporary purposes, without prejudice to both parties to argue. The temporary fee award was agreed to avoid any further hearing or to go into that hearing. That happens all of the time. It used to be in the old courthouse on the 18th floor in front of the general magistrates. Now they have big lounges. People settle cases all the time. We resolve that issue. We set forth a mechanism for payment. One quadro at one time at the end of the case, and you get $5,000 for temporary fees without prejudice to any other argument. There were no contingencies. Nothing underhanded was done here. The trial court judge admitted that he thought it had already been paid. He didn't look at it, and it was just corrected. As for the attorney's fees award, I think I pointed out there were 5 occasions that former husband participated in arguing against my award of attorney's fees. And as you heard in the case right before us, my billing records went in, my retainer went in. There were no questions of me as to my time. In fact, it was only the trial court judge who asked me what period of time I put in after a certain episode, after the temporary fee hearing was. And we explained that to him. He requested all the back and forth correspondence to see what was there for settlement. I testified under oath. Nothing else happened with it. And he did not award me all of my fees. He granted entitlement based upon the award that was given, the incomes, the need and disparity. He determined that. For Mr. Sanchez to say that he wasn't part of it in his brief, he didn't get a chance to participate, is incorrect. Mr. Sanchez has been quite prolific in filing responses, objections to everything that has gone on here. And it was conducted fairly and properly, and my client was determined to need that money, and that was what was awarded. And I thank the court.
Mr. Sanchez, you have another couple minutes.
Your Honors, in reference to the medical expenses, I had been maintaining my former wife's children, 3 other children, on my insurance that whole entire time through the divorce process and prior in the marriage. That was only 2 years and some change that we were married. Not for sure, but I would probably venture to say that's why the lower tribunal judge didn't really err on anything, because I had been covering those expenses for those other children that weren't even mine, and he ordered me to have them removed upon the divorce. The tax exemption, the note was probably because he realized that there was never no tax returns filed by my former wife. On the annual leave, it's not use or leave it, it's use or lose. We have 240 hours in the federal service. You get awarded. If you don't use those, or you can accumulate up to 240 hours. If you don't use anything over those 240 hours, you lose them. I am currently negative 200 plus hours from another accident I stemmed in my job while in Fort Myers on May 29th. I am now negative 200 and plus hours that I've been given advanced annual leave to be able to maintain myself, paying my child support while I'm trying to get treated by the doctors. Time sharing, their calculation and analysis is incorrect. I moved to Fort Myers in February of 2014. If you look at their block of the analysis, they're going back all the way to 2011. Prior to me leaving to Fort Myers, I had my children all of the time as accounted for in the temporary parental agreement done with the mediators 50% of the time. The only exception, in April of 2013, when I sustained a severe automobile accident while on the job and I was in the hospital. During that time, having brain surgery, it was a little difficult to pick up and attend to my children while I had brain surgery and I had my left arm surgically repaired and I couldn't move. That was the only time I didn't have my children, not all the way through 2011 like they claim.
So in conclusion?
As far as the issue wasn't resolved in the $5,000 being awarded, what he says that I had plenty of time, that he was, the email, what he's referring to happened after the fact. After this was brought up in the court at the time of the hearing for the final dissolution of marriage. I'm talking about in the beginning of that year, in March, when we were before the general magistrate. That was agreed to finalize and get to a settlement. We didn't even get to court until November of that year. All those months passed before it finally went to anything. In conclusion, I would just like for these attorney's fees that I've been ordered to pay and the $5,000 be reversed. And I'm assuming it has to go to the tribunal court. Or thank you for your time.
Thank you both. We are